Okay, I think we can start. Hello and welcome to today's webinar, Evaluation, a Potential Tool in a Mediation Strategy, organized by the Department of Law of the University of Trento within the course of Civil Litigation in a comparative context, and in partnership with Resolutia and the Chamber of Arbitration of Venice. The webinar will be presented by Professor Dwight Golan of Suffolk University and by Professor Marjorie Aaron of the University of Cincinnati College of Law. And my name is Luca Dal Puben, and from the University of San Diego State University, and I'll be moderating the webinar today. I would like to thank you for taking time out of your busy schedule and being here today. And now I'm gonna pass the floor, this virtual floor, to Attorney Maurizio Di Rocco, and is one of the organizers and is going to introduce the webinar in Italian. And so I'm gonna leave it to you, Maurizio.
Thank you. Giustamente comincio in inglese, ma... Allora, buongiorno a tutti, molti di voi già mi conoscono, altri no. Sono Maurizio Di Rocco, qui rappresento sia Resolutia che Camera Arbitrale di Venezia e sono veramente molto felice di poter introdurre questo workshop con il professor Golan e la professoressa Aaron, perché credo che sarà un evento molto interessante. Tanto sono anche molto felice del fatto che per esigenze di registrazione si debba cominciare con una brevissima presentazione in italiano, perché il mio inglese avrebbe abbassato sicuramente il livello dell'evento, quindi è stato un sollievo sapere di poter parlare in italiano. Detto questo, brevissima presentazione perché da dove è nata quest'idea. È nata dalla frequentazione ormai di parecchi anni, dal 1999 che mi conosco con Dwight, che è stato un po', anzi non un po', è stato il mio mentore in un corso di mediazione, un corso base di mediazione in quel di Boston, con Gems and Dispute, e quindi parliamo ormai di tanti anni fa. E una cosa che ho sempre apprezzato di Golan, io in questi anni ovviamente mi sono interessato molto, faccio mediatore, formatore, ho sondato molto i vari aspetti della mediazione, i vari approcci, i vari stili, le varie tecniche, e una cosa che ho sempre apprezzato è stato poter verificare mano a mano che ci si muove sugli orizzonti della mediazione l'efficacia del pragmatismo, che è sempre stata la cifra distintiva di quello che insegna Dwight, di come lo insegna Dwight. E credo che dipenda, anzi sono sicuro dipende dal fatto che Dwight è un ottimo conoscitore del mondo forense, e quindi diciamo che la sua visione della mediazione è una visione che tiene sempre presente il mondo forense e l'avvocatura, e non è quindi una visione che si contrappone all'azione degli avvocati e alla loro presenza in mediazione. E questo ha sempre rappresentato un elemento del tutto distintivo, e che risulta poi nella pratica particolarmente efficace, perché si va ad esplorare, si possono fare delle riflessioni molto più interessanti su quelle sinergie che si creano tra avvocati e mediatori all'interno di una procedura. Tanto più in un contesto come il nostro, dove la presenza degli avvocati è una presenza quasi imposta, almeno così lo è stata dal 2013 in poi, e dove quindi c'è diciamo una presenza con la quale volente o nolente si ha a che fare, e dove poi ci sono degli input che sempre più di frequente vengono anche dalla magistratura, che è quello di voler coinvolgere i mediatori in un'opera di diciamo così, deflazione, contenimento del contenzioso, e quindi attribuendo a loro anche un ruolo prettamente consulenziale quasi nei confronti delle parti. Quindi la figura del mediatore valutatore, del mediatore che interviene in qualche modo in senso, chiamiamo così, proattivo nel contenzioso delle parti, è una figura che nel nostro contesto volenti o nolenti è particolarmente diffusa, è una figura con cui bisogna avere a che fare. E detto questo, so anche perfettamente che per molti che si occupano di mediazione parlare di mediatore valutativo è un tabù, diciamo la verità, la cui violazione in taluni genera una vera e propria ripugnanza. Però io credo che si debba diciamo approfondire, e questo sia doveroso approfondire anche questo aspetto dell'azione del mediatore senza pregiudizi, senza preconcetti, valutandola per quella che è, per l'utilità che può dare e con la consapevolezza di come la si può porre in essere nel modo migliore. Quindi, detto questo, ho promesso di essere molto breve per non portare via tempo agli oratori che mi seguono. Io auguro veramente un buon lavoro e ripeto, con la gioia di vedere di nuovo Dwight e la professoressa Aaron condurci per mano in un altro evento di questo tipo. Grazie, buon lavoro.
Well, thank you very much, Maurizio, for your introduction in beautiful Italian. I'm now going to leave the microphone to Professor Silvana Dalla Bontà for the opening remarks.
Well, as Luca and Maurizio have already emphasized, it's more than a pleasure, it's an honor to host Dwight Golan and Major Aaron today at the University of Trento Faculty of Law within the Bachelor in Comparative European and International Legal Studies in the framework of the Conflict Managers of Tomorrow project. As professor at Suffolk University and brilliant author of several publications on mediation, mediation advocacy, mediation strategies, and mediator styles, Golan is one of the most distinguished authorities in the field, and we are privileged to host his insightful keynote speech on evaluation, a potential tool in a mediation strategy. His presentation on this very interesting subject, which Golan is giving along with the Professor Major Aaron, professor at Cincinnati University, fits perfectly into the educational and training programs that the University of Trento and the Conflict Managers of Tomorrow project particularly have been promoting and developing for years. Golan's view of the role of evaluation in the mediation process is one of the most stimulating facets of the ongoing debate on effective management of mediation tables. Evaluation is indeed a controversial issue. Some mediation theorists, as Maurizio said, believe that evaluation has no place in true mediation. They see mediation as a purely facilitative process in which parties are left free to make their own judgments about the merits of the case without interference from the mediator. Golan holds a different view, arguing that evaluation is a legitimate weapon in the mediator's arsenal, a weapon that can be either effective or explosive, depending on how and when it is used. In fact, in some cases, effective employment of evaluation might resolve disputes between parties who hold unrealistic views of the merits of the case, whereas in other cases, its use might be very risky. As said, Golan's lecture on the role played by evaluation in mediation tables fits perfectly into the educational and training programs that the Conflict Managers of Tomorrow project of the University of Trento has been promoting and developing from years. From the perspective of the use of the evaluative weapon by the mediator, Golan's keynote speech also highlighted the importance of mediation advocacy. And as we know, when we talk about mediation advocacy, we talk about the lawyer's techniques of presenting and defending clients' positions, clients' needs, and clients' interests at the mediation table. These techniques are rather different from those required in litigation. They encompass a wide spectrum of skills that need to be specifically acquired, such as awareness of the different roles played by the lawyer and the client at the mediation table. The lawyer cannot uncritically act as a litigator during the mediation process. The traditional view of the in-charge lawyer, who is entrusted with the power to conduct the proceedings as the sole owner of the litigation, is neither appropriate nor effective at the mediation table. On the contrary, Acknowledging the client's ownership of the dispute fosters his empowerment, providing it the first step towards an effective mediation advocacy. Furthermore, effective mediation advocacy entails the lawyer's awareness of the importance of preparing for mediation. This means that the lawyer should consider and weigh a variety of factors before embarking on mediation. And just to mention a few of these factors, the good lawyer should ask himself or herself, should the client mediate? In other words, should mediation be considered appropriate to solve the client's case? And in this regard, even the first lawyer's interview with the client is decisive. Asking the client the right questions is the best means to identify their interests and needs, and thus to assess whether mediation is the best option of solving their conflict. Another factor that the good lawyer who masters mediation advocacy should consider is which type of mediator would be of most assistance in the client's case. A good facilitator, a technical expert, an evaluator, and furthermore, which style should the mediator use in the client's case? Facilitative or directive, evaluative or non-evaluative, right-based or interest-based, transformative or deal-making. The lawyer who effectively assists the client in solving their conflict should help select the appropriate mediator, and this selection shouldn't be random. Another factor that the good lawyer who masters mediation advocacy should consider is how to prepare the client for the mediation table. A good presentation of mediation as an alternative to court litigation and a comprehensive explanation of features, stages, goals of mediation process are fundamental to prepare the client for the mediation table. Furthermore, it is crucial to establish a solid working relationship between lawyer and client. Teamwork is an essential component for an effective and efficient use of mediation. While master mediation advocacy also means to effectively manage the mediation table. Thus, the good lawyer assisting the client should ask himself or herself how to make an opening statement. That is to say, how to present the client's position, how to set a good, collaborative and respectful tone, how to choose an appropriate negotiation style according to the client's interests and goals, and how and when to ask questions to the other party, how and when to make the first offer to the other party, how to use the mediator, and in this regard, how to feed the mediator. Because the more information you feed to the mediator, the more the mediator will be able to help restore the communication between the conflicting parties and reach a mutually beneficial agreement. Then how to ask for the mediator's help? Effective mediation advocacy also entails asking the mediator's assistance to manage the process, to convey messages to the other party more effectively, to get information from the other party, to give feedback on risks, strategy, and offers. But also effective mediation advocacy means to ask for a private session at the appropriate time. And when we talk about a private session, we talk about caucus or cross caucus. How to encourage brainstorming, to develop new options, and to create win-win solutions, to overcome pitfalls, difficult conversations, escalation, how to know when the client should walk away and which walk-away strategy should they adopt. Well, acquiring and mastering all these skills is essential for any lawyer who wants to meet the client's expectations and needs, and thus to be competitive in the legal market. Emphasizing the importance of mediation advocacy as an expertise complementary to the legal knowledge that lawyers possess is especially crucial in civil law legal systems and is particularly crucial in the Italian legal system. As we know, in the Italian legal system, a strong cultural background has influenced the general perception of what justice is and how justice is served and achieved. In our legal system, the common perception of justice is characterized by a court-centered view. In other words, in-court proceedings have been traditionally seen as the natural and most appropriate, if not the unique, mechanism to resolve disputes. And this has shaped the lawyer paradigm in such a way as the lawyer is solely seen as a litigator and not as a professional negotiator who knows how to effectively manage the conflict in all its nuances. Generally, when a traditionally formed lawyer negotiates, he or she negotiates based on instinct or experience gained during his or her practice, but without a specific education in training on negotiation and mediation. This does not mean that some lawyers are bad at negotiating or mediating, but if they are good, it depends more on their natural talent than a dedicated and structured education and training. Well, the times are now ripe for a significant paradigm shift also in our legal system, a shift that will finally recognize the added value of mediation advocacy for resolution of disputes. And significant pressure in this direction has come from the European Union, from the global context, and from the national context. Regarding the European Union, from a long time, the European Union has highlighted the importance of mediation advocacy and the role that universities should play in educating tomorrow's lawyers to properly and effectively act as a counsels of the parties at negotiation and mediation tables. A study promoted by the EU Parliament titled Rebooting the EU Mediation Directive, released in 2014, showed that promoting mediation advocacy is one of the most effective non-legislative tools for building a mediation culture in the European legal area. More precisely, this study argued that launching and investing in educational and training programs in mediation advocacy could change the traditional perception of resolving disputes. And researchers emphasize that knowing what mediation advocacy is and what skills it requires would be the most impactful tool in promoting a bottom-up cultural change. And the EU Parliament study encouraged university and especially law schools and business schools to establish and or develop mediation advocacy education programs. These programs should include preparation for participation in national and international mediation competitions, such as the ICC International Commercial Mediation Competition held in Paris. And training through role plays is considered one of the most effective ways to learn mediation advocacy skills and then to put them into practical and real professional life. Universities around Europe have certainly responded to that encouragement, and the University of Trento has embraced this idea through the Conflict Managers of Tomorrow project, which successfully prepares the students for participation in mediation competitions, where the student also play the role of the lawyer assisting one of the disputing parties at the mediation table. And the ultimate goal of the Conflict Managers of Tomorrow project is to train a generation of settlement-oriented young professionals equipped with a solid set of mediation and negotiation skills. While the increasing importance of mediation advocacy has also emerged at the international level, the UNCITRAL, United Nations Commission on International Trade Law, is showing ongoing interest in conciliation and mediation. In 2018, UNCITRAL adopted the model law on the international commercial mediation and international settlement agreements from mediation, which replaced the previous UNCITRAL model law on conciliation. And last year, Singapore Mediation Convention entered into force, and Singapore Mediation Convention is a uniform and efficient framework for international settlement agreements resulting from mediation. It aims to facilitate international trade and commerce by enabling disputing parties to easily enforce and invoke mediation agreements across borders. The adoption of the Singapore Convention is one of the strongest pieces of evidence of businesses' growing reliance on mediation as an additional dispute resolution option to litigation and arbitration in settling cross-border dispute. Lawyers who practice internationally are thus required to successfully manage cross-border mediation tables. Effective mediation advocacy entails knowing not only various legal systems, but also different cultures and being able to move from a multicultural to a cross-cultural approach. And mastering these complex sets of skills to assist international clients appears to be almost impossible without education and training on effective management of transnational mediation tables. And universities are expected to keep up with the emerging market and thus to provide tomorrow's lawyers with the tools they need to offer their clients the best mediation advocacy. Calls to promote mediation advocacy have recently come also from within the national context, fortunately. And one of the most prominent calls to promote mediation advocacy is represented by a judgment rendered by the Italian Corte di Cassazione in 2019. In an obiter dictum, the Corte di Cassazione clearly stated that the lawyer who assists the party in the mediation process should possess negotiation skills. Indeed, a new professional has emerged. This new lawyer is required to play a new role, and thus he should learn and use other skills than the traditional ones. They are interpersonal and emotional skills. They include the ability to identify and understand the needs of the parties, which are broader than their asserted legal positions. These statements present an explicit recognition in our legal system of the current and urgent need to rethink the role the lawyer can play in assisting the client in resolving their conflict. The traditional view of the lawyer as a mere litigator, only focused on court litigation, is nowadays obsolete. This is also emphasized by the commentary on the Charter of Core Principles of the European Legal Profession, adopted by the Council of Bars and Law Societies of Europe, which highlights the lawyer who faithfully serves his or her own client's interests also fulfills the functions of the lawyer in society, which are to forestall and prevent conflicts. The same principles are expressed in the Mediation Development Toolkit issued by the EU Commission and aimed at ensuring the implementation of the guidelines on mediation adopted by the Council of European Commission for the Efficiency of Justice. The toolkit underlines that it is of utmost importance that lawyers can demonstrate a deep awareness and appropriate technical skills that are necessary in order to effectively support clients in all types of disputes and resolution procedures, both adjudicative and amicable, including also mediation. Thus, while a lawyer remains a legal expert asked to legally qualify a dispute, the lawyer is today also required to be something more. What? Is required to be an assistant to the client in choosing and pursuing the dispute resolution mechanism that is most suitable for the client's needs. This entails the lawyer's ability to effectively manage the mediation table, whether a domestic or a transnational one. And part of this ability is knowing which mediation style might be used by the mediator through the mediation process. And this is why we feel so privileged to host Dwight Golan and Marjorie Aaron here today. As one of the foremost authorities of the evaluative mediation style, Dwight, along with Marjorie, can educate us on the power of the evaluation at the mediation table. And so I thank you, Dwight and Marjorie, to be here again. Thank you.
Well, thank you so much, Professor Dalla Bontà. Thank you for your brilliant opening remarks and also for giving us a comprehensive overview of the importance of mediation advocacy. And this actually leads us to the subject of our webinar today. And before I give the floor to our guest speakers, I would like to go over a few logistics. So the presentation will go for roughly 2 hours. We will take a break in between. So we'll take a break around 5:30, and I would say a 10-minute break. So to allow everyone to stretch their legs and get a cup of coffee or better an espresso. But we will reconvene sharply at 5:40. And feel free as we go, if we have any questions, to leave it in the chat room on the right side of your screen, and we'll collect a few of them and then address those questions at the end of the break as well. Also, we will be running a Q&A at the end of the webinar. Again, a few questions. Unfortunately, I'm not sure we'll be able to address every single question because we don't have that much time today. Also, let me give the instructions also in Italian to be clear. Ringrazio innanzitutto di nuovo la professoressa Dalla Bontà per la sua brillante presentazione. E prima di dare la parola ai nostri ospiti, vorrei ricordarvi che questa presentazione durerà circa 2 ore, e quindi abbiamo pensato di fare un piccolo break verso le 5:30. Una decina di minuti, giusto il tempo per un caffè, e poi ci ritroveremo alle 5:40. Se avete delle domande, portate pazienza e mettetele nella nostra chat. La professoressa Dalla Bontà e io e l'avvocato Di Rocco raccoglieremo alcune di queste domande che poi verranno risposte dai nostri ospiti alla fine quando ci ritroveremo prima dell'inizio della seconda parte. Inoltre i nostri ospiti risponderanno a delle domande anche alla fine della presentazione. Questo è tutto. Se avete domande riguardo queste logistics, come le chiamiamo in inglese, fatelo pure nella chat. And now I would like to give the microphone and the virtual floor to our guest speakers, and I'm very delighted and honored to introduce Professor Dwight Golan and Professor Marjorie Aaron. I would like to thank them to be here today and give us a brilliant and beautiful presentation. I'm sure it will be a brilliant and beautiful presentation. To you, Golan and Aaron.
Well, let me begin by thanking Professor Dalla Bontà, Professor Del Pubel, and my good friend Maurizio Di Rocco for inviting me, and also my friend and collaborator, Professor Marjorie Aaron. We are going to do this together a little, we hope, like good football players passing the ball back and forth and hopefully scoring a goal at the end. Occasionally the ball may bounce off our foot, but if you will bear with us, I think it will be interesting. We would like to not simply speak to you. Yes, we have a few PowerPoints. We also have video, which we have shot of mediators from around the United States, but also in Africa, Asia, and Europe. And we'll show you a little bits of that video where you will see what the mediators are doing and form your own impressions. I would say that if I were, I should mention, this may seem like an introductory program, but yesterday, as it happens, the International Association of Mediators, a group of professionals who each do 100 mediations or more every year, this is their profession, held a seminar. It was the best attended seminar of the year. What was the topic? Evaluation. Everyone was interested, and the people from Africa and Europe disagreed with the people from Canada and the United States, but so it is. I think of it, and I don't think Marjorie is too far different. I'm not a real doctor. But in a sense, I'm a doctor. I'm a doctor of sick negotiations. No one ever asks me to get involved in a negotiation that is going well. It is always sick with some problem, some illness. My job is to diagnose the illness and treat it. Now imagine I'm at a hospital, your local hospital near Trento. If you went in with a problem to the hospital, you would not want the doctor to say, oh, let's cut you open and see what's going on inside. That would be the last thing you would want. You would want them to talk to you. You would want them to prescribe simple treatment, more complex with maybe side effects. And you would want the hospital to have a department of surgery, just in case. Not to be used all the time, not to be used first, but there. I think of evaluation as the surgery of mediation. So let's talk about what this surgery is and how to do it well. If we have time, we could talk about how the doctors, the lawyers try to help the surgeons, you could say, and influence the result of the operation, but that's a different question. So let me share screen and begin. So if evaluation is a potential tool in a mediation strategy, let me talk about how American lawyers, at least, see evaluation, understanding this is not how other lawyers necessarily see them. When the American Bar Association asked lawyers, what actions do you think would be good in at least half of your cases of a mediator? 95% of them wanted pointed questions that raise issues. 95% wanted an analysis, including strengths and weaknesses in half or more of their cases. 60% wanted a prediction about what would happen in court. 84% wanted a specific settlement. 74% wanted us to apply some pressure to accept a solution. That's a whole nother ethical issue, which I will not deal with today. If you look internationally, it's much more variable. Ask the question, I assess and share my opinion regarding the legal strength of arguments made by parties and/or counsel. Do I do it never? Sometimes, about half the time, usually, or always? From all responding mediators, this is in the International Academy of Mediators, it was split in a nice bell-shaped curve. But if you look at mediators practicing in California, the middle row, 50% do it usually, 12% do it always, 14% do it about half the time. If you look at mediators international outside the United States, it is heavily voted toward never or sometimes, with very little doing it usually or always. So great variation in practice. I will save the rest of my comments about this slide and turn the microphone over to Marjorie.
Okay. Thank you, Dwight. It's really a pleasure to be here, and I thank the organizers and the professors for allowing me to work with Dwight in this program. I will say that there's a certain can we undo the screen? Oh, you want to keep? Are we keeping the screen share, Dwight? Yeah.
Undo the screen share. Sure.
I think that's right. Yeah. So I'm really delighted to be here and to have been invited to participate. There's the wonderful truth, I think, is that the first time Dwight and I ever collaborated was on a chapter about evaluation in mediation in the first edition of Dwight's book, which was in 1995 or 1996, right?
Yeah,
I think that's right. Yeah. So it's everything comes full circle, except that we're in Italy instead of Boston. So it's lovely to be here. I want to talk a little bit about mediation and evaluation, obviously, but one of the things that occurs to me is that I assume, maybe I'm wrong, that everybody here at some point in a mediation that you're mediating thinks, oh my, one of the people here, it might be all of the people here, have an entirely unrealistic view of what's going to happen with this case if it goes to court. Here we say they're in la la land. They really are they're unrealistic about what their alternatives are. If that's true, if you're experiencing that feeling, then that means that you have a view of what realistic is. And so I would suggest, and I think, Dwight, you could put the PowerPoint up now, the number 4. I would suggest actually that experienced mediators, oh, here we go. Where are we? Number 4.
Yeah.
Our observations is that experienced mediators evaluate constantly. And so I mean that in 2 ways. One is internally, unless we can just drop the analytical part of our brains, we are evaluating as we go. Sometimes we may jump to an evaluation conclusion too quickly and close out, but that's a whole nother piece of psychology, which is a bad thing. But we are evaluating constantly. And then what happens is that I would suggest, and this is partially, by the way, based on Dwight's wonderful research, as opposed to just observations that I make or have made in various training sessions. I have had the opportunity to co-mediate when I was with what was then Undisputed and is now JAMS, but most of the times mediators are working alone. So we don't see what other mediators do, but Dwight has done some wonderful research on this. We've collaborated on some videos, and he takes the video prize, has done more. And I know that we've both had the opportunity to observe mediators who are even reasonably experienced when we do training sessions. But from all of that, what I'll call data or observation, what we see is that experienced mediators are constantly evaluating, and very often those evaluations are expressed in one way or another. And that one way or another piece is really what we're talking about. Most of the time, we think about, mediators evaluate, think about, at least internally, a whole range of things that are happening in the mediation. Most of the time, we try to keep our opinions confidential if we're trying to be facilitative and not express that. Having said that, either intentionally or unintentionally, we often communicate at least part of what we're feeling or thinking through a phrase or a gesture. So people are reading and understanding that we're not very convinced on that score, even if we haven't quite said it. Oftentimes when mediators evaluate, even if they are intending to communicate that, they will very often do it with prose, with words. So they'll say, well, this is pretty good, or gee, this is a little risky. That the tendency is to do it that way, as opposed to numerically. Mediators tend to offer what they think verbally, as opposed to in writing, although we'll talk about the fact that sometimes in writing can be really useful. And mediators tend, when they are evaluative, to do so on a single issue, as opposed to here's what I think about the whole thing. And so one of the purposes of today is to explore the extent to which we're being intentional or unintentional, and also the extent to which, even if you've never shied away from giving feedback on a single issue, whether there are times that it might make sense to make your evaluation more explicit and maybe covering a broader range of things. But those, if you're going to do that, and this really is our punchline, if you're going to do that, you need to be skillful, because it is surgery. It is dangerous. You want to move to the next PowerPoint, Dwight? Okay. So the question then becomes, if we look at evaluating before we focus on the surgery part, one of the ways that mediators often evaluate, again, either internally or communicating it, is they get an offer, and they, because they've been in the other room, the other caucus room, or because they know something about the perspective, often are evaluating the bargaining moves. And here, based on what I know, here's how I evaluate this offer will be received by the other side. And not just moves, but certain tactics. One side will seek to exercise a tactic. Then the mediator may have a point of view about whether as a matter of mediation advocacy, that's going to be helpful or unhelpful in the mediation. Let's go to the next interest. Okay. Also, we evaluate, we think about, we analyze the impact of a conflict on someone's personal interests. And I would say that oftentimes the lawyers are wrapped up in what the conflict is worth in terms of the court system and whether they're going to win or lose and whether they'll be happy or sad. But sometimes there has not been careful thought about what will that really mean for the customer's business or personal life. And so those interests, sometimes parties and lawyers come into a mediation without having thought those things through. And sometimes the mediator at least initiates a discussion and a thought process about what those things will mean. And then last but not least, let's go to legal issues. The more traditional way that we think about what does it mean when we say a mediator is evaluating is that the mediator is evaluating legal issues. Sometimes the mediator is saying, well, in order to really assess that issue, or in order for your judgment about that issue to be worth anything, you're going to need more information. You don't have information, you may be leaping to a conclusion. A mediator is sometimes providing, or again, at least thinking about which issues seem to be more and less important, especially if you're analyzing what might happen in court, what the costs are. Sometimes people haven't thought about it, or they haven't talked about it, or they haven't been realistic about it. And then also, sometimes the mediator is indeed, at least internally, and then we'll talk about externally, evaluating what will happen if this issue or the whole case is adjudicated. And so those are the realms within which a mediator is thinking evaluatively sometimes, and then either explicitly or implicitly communicating that or not. And a lot of the focus on today, although not exclusively, is the benefits and the risks and the techniques associated with evaluating legal issues. But we will not only be talking about that. I think that's where we are. I think what we wanted to do was show you some of these videos. Yes. Some of them have Dwight and me in them.
Yes, let's start with you, Marjorie.
Yeah, I know. It doesn't matter. But when Dwight dragged me into this video project, with which I'm happy, we at least figured that we could demonstrate what we wanted to demonstrate instead of hoping that someone else could do it. And we intended some of these to be a bit edgy. Would that be fair?
Yes.
Yeah. So this one was
really
more
edgy parts, but yes.
Yeah, we're not showing so much of that. But these we were intentionally exhibiting certain kinds of things. Okay, Dwight, you're going to talk about my video. I'm going to talk about yours.
I will, at the end of the program, give you a link, which if you want to see the video of me and Marjorie with 22 chapters, a total of an hour and a half, you're welcome to go on YouTube and watch it. However, we don't have that kind of time. So I take a mediation process that lasts 8 to 12 hours. I boil it down to a video that's an hour and 45 minutes. And then I show you 1 minute and 22 seconds of that video. So obviously I can't show you the whole thing. You have to imagine everything that happened before, everything that will happen afterwards. And now I show you just a little slice so that I can show you different mediators, not just me, not just Marjorie. So first case, let me give you, and I'll introduce the case.
Yeah.
This is because it's shown on 3 different videos, actually. Mumbai Partners is a small Indian company. It gets an exclusive contract from MedPro, a large American company, to distribute pulse oximeters, which are medical devices. It has an exclusive assignment for Southern India. They spent 5 years, almost $500,000 US, developing the market. Sales rose rapidly up to 800,000 a year, then they dropped. MedPro terminates Mumbai on 45 days notice for cause. Their contract does allow either side to terminate for cause, or on 90 days notice without cause, or on the anniversary date of the contract. Mumbai sues MedPro in the US courts for $2 million in future lost profits, saying we had a long-term relationship. The sales drop was due to national economic problems with the government of India not being able to fund hospitals. It's not our fault. So now imagine this mediation started with pre-mediation meetings with each side, which are shown on the video, an opening session. Then Marjorie takes the defense side, MedPro, the American company, and talks to them for half, 3/4 of an hour about all the legal issues, everything. But finally, it's time to talk about offers.
It would be helpful to me.
Excuse me, let me just stop to make sure that we are sound optimized. Yep, we are good.
To have a number to go back with.
I think this.
You want to talk about it?
We might need
okay,
to talk
that's
about
fine. Well, I knocked on the door and you said you were ready. And do you have a number for me?
Well, we've talked about the frames of reference that you used, and the number that we feel we can put out there, given all of my concerns and reluctances, is 50,000. And I can talk to that if you would like, and sort of explain how we got there, what it signifies.
You gave me a number. I asked you for a number. Look, I appreciate that $50,000 is not an inconsequential sum of money.
First evaluation, $50,000 is not an inconsequential sum of money. You would predict that the plaintiffs who are asking for $2 million would not regard $50,000 as very much money. They would regard it as totally inconsequential, probably insulting. But Marjorie is in the defense room, not the plaintiff room.
Especially if actually you had the right to terminate in the 30 days. In which case you would either owe nothing or $20,000 or something like that. Am I right? What do you suspect their response will be?
Who knows?
That would have been my problem, right?
I mean, I don't think they're going to be thrilled with it.
You want to send a message. One of the things that worries me a little bit is that the 50 may send an even lower signal than maybe you would have intended. What do you think about that one?
If we were in a small classroom, I would ask all of you to give opinions about what it was she was giving an opinion about. But since we have a very large group, let me suggest that she is not evaluating who is going to win. She is not evaluating what is the right outcome. She's not evaluating interest. She is evaluating what will be the reaction in the other room. Now, she does it by asking questions, but if you did not hear an opinion in those questions, they need to be translated into Italian, I guess. Let me move on.
Sorry.
Yeah, Marjorie?
I was just going to say, and I haven't watched my own in a while, but it's also saying, are you sure this is tactically what you want to do? Because it may be sending a different signal than you want to send. So it's actually both of those things, I think. But you're right. I'm asking a question, but I'm telling them, I don't think your signals are aligned. Yeah, no, you're right.
And you then go on to suggest they send a different signal, and you bargain with them over the signal, but not, we'll move on.
Lots of bargaining, yeah.
A second case, different case. These are all actual cases. Why bother with making up stories when you have real ones? All right, so there's a Hong Kong businessman based in Hong Kong, contracts with a small US company that he's going to distribute their software in mainland China. It goes well, but the small company encounters cash flow problems. As happens in Hong Kong, the owner transfers almost $2 million to the American company. They view it as a loan, but there is no loan documentation. It's just an assistance to a friend, and it's reflected as, I think, unshipped inventory on the monitor books. But they changed the contract, so now the Hong Kong businessman will get higher commissions until he's been paid the 1.9 million, and for a while he is paid. But then Monitor is bought out by a big US company called Green, whose attitude is, if it is not on the books, it does not exist. So they say there is no loan here. SDP sues Green for the loan. And I'd like to join the mediation at the second meeting that the mediator, Michael Lewis, one of the most distinguished American mediators, holds with Green Consulting. Marjorie,
I'm up. Yep.
up.
So, got a fairly significant move from them I want to talk to you about, and then need to ask you to think seriously and make a response. They have moved to 1.375, and that is a reduction of $100,000 off of what they actually believe they are due. I need a response from you.
Let us consult. We'll get back to you.
Okay, absolutely. So, where are you?
Well, a couple of thoughts. We value the case at $250,000, the cost of defense. So we would offer a net $250,000 to them. And I'm not going to say that's our last and final offer, but that reflects our view of the value of this situation to us.
So, it's only going to cost Green Consulting $250 to try this?
We'll see.
Surprises me. So, and you said earlier you'd like to put this behind you.
Right.
And frankly, I don't think 250 will do it. The problem is, of course, if this doesn't settle, you're going to be spending a lot more time in rooms like,
Right.
you know.
And we all know I have no interest in that.
Yeah.
Ms. Wong, Simon.
Any comments, Marjorie? You're muted. You're muted.
Again, I would be saying, if this were my class, I would be saying, so what did you see? But I'm going to stand in for the group and say, one of the things that, and you notice he had this little smile on his face, like he almost laughed. He didn't laugh, but he was saying, I'm amused by your estimate of 250, but he's questioning whether the lawyer is being realistic or honest when he says that that's what the fees will be. And he also is very clearly saying the case isn't going to settle for that much. So he's giving them feedback on whether the lawyer is being realistic or even realistically in the ballpark. And then he's, I think, providing feedback on the fact and raising the salience of the idea that the client is going to be stuck in rooms like this or in the court proceeding for more and for longer than she is necessarily thinking about, and that will be a consequence for this client. And so it's worth thinking that through. So he's really doing three things, I think, in quite a skillful way. But that look on his face, I laugh at because he's thinking, yeah, really, 250, give me a break. And he does it so nicely. That's what I see.
Because the lawyer knows it too, and the executive knows it too. They're playing a little bargaining game here. But
yep.
On we go. So now we're going to move to Asia. We decided, I was in Hong Kong to do training in evaluative mediation, and decided to take the opportunity to film the chair of the Mediation Society of Hong Kong, Jody Sin, and the chair of the Mediation Society of Singapore, Lim Tat, doing the same case as the Indian case, but now set with the small company being in mainland China and the process being arbitration in the Hong Kong International Arbitration Center. So again, we jump ahead for hours. This is 3 hours into the mediation, all right? And you just have to imagine we can all go there. And here's what we see.
Interest in that.
Yeah.
Ms. Wong, Simon, welcome back. All right, I think we've made some progress here. I wish to understand your perspective as to potential outcomes. If this case proceeds to an arbitration, the best scenario will be the notice of termination is valid, right? So in that case, Medpool will be paying out 0. What is the other likely outcome then? Can you just remind me?
Now notice she has now created a little chart with 3 outcomes, and she has asked the lawyer, those are the red numbers, to indicate the likelihood of each one. Marjorie will demonstrate this with more precision later, but let's watch what she does after the analysis.
What's the likely legal costs that your client will need to bear when this case proceeds to arbitration?
It would be around $300,000.
So even if you win, like under the first scenario, I think Simon will be able to advise Ms. Fong as to the possibility of recovering, even if you fall into scenario 1, recovering the legal costs from GMS.
Yes, I think there is a risk involved that any award that you obtain from the arbitral tribunal could not be enforced against GMS.
I hope you could work out what's the next number that you could offer to the other side.
So I will stop just to mention, here we're dealing with the costs of litigation, or rather the likelihood, because under the rules, as I think they are in Italy as well, in Hong Kong, the winner can get their legal costs and the costs of the arbitration, recover them from the loser. But she's raising the question, so you get an award, now you're trying to chase a little company in mainland China to get them to pay the money. How likely is that? And she has given the lawyer a springboard for answering that question in front of, which is not good news, in front of his client. Now, the question is, has she given any evaluation by raising that issue with that expression on her face? My suggestion is yes. Everyone knows what her opinion is, and now the lawyer can confirm it. And now, you were waiting. We will finally give you an actual evaluation of a legal issue, right, Marjorie? Do you want to describe the culture bubble facts?
Oh gosh, culture bubble. Yeah, why don't you? I wrote it, but it's been a while.
Marjorie's case. She made it up. I think she mediated it.
I did.
Let's assume a company is establishing an amusement park near Milan. It wants it to be a very dramatic park, so it needs lifts to lift people up the stage and fancy. So it waits until the last minute to order lifts. And then suddenly it contracts for the lifts. They have oral discussions and then later a signed contract. The lifts question when the lifts are supposed to arrive. They finally get there just before the opening, and they're too big to fit the holes in the stage. And there are technical reasons for that, but so now one of the questions is, when were the lifts actually due under the contract? And the plaintiff says, well, it's when we agreed. The defendant says, no, it's when we signed the contract. That's when the 12 weeks starts to run. And we're getting to the point where the lawyer has asked the mediator, would you please talk to my client about this issue, the plaintiff, because she just doesn't understand.
Yeah, and just to add, that's exactly right. And it was based on a case I mediated in Cincinnati that I made more complicated. But the other thing I was just going to say was that it matters because if they were actually due at the earlier date, then it's quite simple to prove a certain chunk of damages. But if they were due at the later date, then that piece of the damages falls out of the case. So it very much affects the case value. Okay, let's see.
There was one other part about going into court that I thought it would be helpful for us to discuss. The two things that I worry about for your case, CJ, in terms of how a judge might look at it. We all know exactly what the conversation was that you all had. And part of the dilemma is that got reduced into a written document called a contract and signed. And what the contract says is July. And one of the great dangers for you is if it got to court and if a judge took a sort of a strict constructionist position, and this can happen an awful lot, where he says, look, the written words are July. Now, that has the huge implication for the dollars. And so there's a real risk here. And in thinking about how you formulate a further proposal, I think it's important to really reflect on how much risk there could be there.
Yeah.
Well, we ought to talk about that. Appreciate your take on this.
Okay, let me stop.
I'm I'm the commentator where if we were in class, I would be saying, so what do you think? But I think I think he does a very skillful job. He is analyzing that legal issue relating to a topic we'll talk about later, which is how to. He does a very nice job at the beginning of it, of reflecting her take on it, and then going into why the judge, a judge might see, or court might see it differently. But he's clearly communicating that he thinks this issue is a big problem for her. And I think you can judge whether you think he does it skillfully.
And we will return later.
We'll return. Yep.
Your opinion about what actually he said, because it's not so clear. But before that, we want to take a few minutes. Why is it that parties and lawyers and mediators maybe might not assess the legal issues correctly? What are the cognitive mental barriers that affect it? So it's just a few minutes. This is a longer topic, but we want to just take a moment. So Marjorie did an experiment, and I would like her to describe the experiment she did. Let me see.
So this experiment was so long ago that my hair was brown. And maybe naturally, but we did an experiment at Harvard, and because I used to work at the Harvard, I was the executive director for the Harvard Program on Negotiation, and I also did some work at Harvard Business School. There was a case, a personal injury case that we developed, and we had that negotiated with business students and law students, and we asked, based on the same information, we asked those who were on the plaintiff side and those who were on the defense side what they thought their likely chance of their client or their side winning, and then what we thought the damages would be if the plaintiffs did win. And if you want to put that up, Dwight, you want to put that up?
Well, there's the first one, and then what will she win?
It's not on my. Did you put it up?
Oh, I'm sorry. Excuse me. I always forget to screen share. That's my problem.
You're the master of trades here.
All right, there it is. You can
Almost.
see it now, I hope.
So here it is. Yeah. And what you see is that the cumulative, where is it? Here we go.
Coming on.
Here we go. The cumulative, how come it keeps bouncing off? But anyway, the cumulative chances of success are over 100%. And actually, and there's a discrepancy, a pretty sizable one on the damages estimate. And I will just tell you that I've done a variation, and Dwight has, of this experiment using different cases. And these differences between the way they evaluate the case are actually pretty modest. In one case I did based on the same damages for spreadsheet, very often the defense thinks that if the plaintiff wins, they're going to get, X amount of dollars, and the plaintiff thinks if they win, they're going to get 5 times those many dollars. But just in general, the point would be that there is such a thing as partisan perception bias, as well as overconfidence, and Dwight will speak to that. And that is very often what drives an impasse in a mediation. If I think I've got a 75% chance of winning, and you think the opposite, and by the way, the other side thinks they're going to win on their counterclaim, then the cumulative chances of success add up to 150%. And if that's how they're basing their settlement moves, they're not going to settle. There's going to be a gap.
I'll just note, the interesting thing about this experiment is both sides were told they were getting confidential information, but Marjorie tricked them. All the information was identical. They just put a different title on the page. So they are with the same information, which is not true in a real case. But even with the same information, you get this variation.
Yep.
Now, next problem. And now, since I'm a professor, we'll have a quiz, little test. I'm going to ask you 6 questions. You need something to write down your answers. Now, I know that in this quiz, you do not know the actual answer. So I'd like you to pick a range so there is a 9 in 10 chance that the true answer is within your range. So for example, if I asked you, how old am I? And you guessed 58, you would be wrong. But if you guessed 50 to 80, you have a better than 90% chance of being right. So I'm asking you to pick a range so that you have a 9 out of 10 chance that the correct answer falls in the range. You don't need to give me the actual answer. So here are the 6 questions. First question, how old was Giuseppe Garibaldi at his death? A low and a high for the founder, one might say, of modern Italy. Everybody write it down. No looking on the internet. This is of your personal knowledge, all right? But you can do a range. Next question. How long is the Nile River? In kilometers or, well, kilometers, we'll say. Nile is much closer to Italy than the United States, so this should give you a little advantage. All right. Third question. How many member countries are there in the Organization of Petroleum Exporting Countries? You know Saudi Arabia is in it, Russia is in it. How many are there? High and low. Now, the next one should be easy for Italian people. The number of books in the Old Testament. You all had to study this in church school. So how many books are there in the Old Testament? A low and a high. Fifth question. What is the weight of an empty Boeing 747 airplane? No passengers, no gasoline, no luggage, just the airplane, big airplane. It has that bulbous nose on top, so it's thicker on the top, big airplane. You can give it in tons. And a final question. What is the gestation period of an Asian elephant? That is, how long is the elephant in the stomach of the mother? This is the Asian elephant with the small ears and the tuft on the top, not the African elephant, which has big ears, okay? Everybody personally written down their answers. And now, here's what I'm going to do. I would like you to please turn on your cameras, if you will, just for a moment. If you will, I would like it if you would turn on your cameras, and there's a reason for it. I would like you to raise your hand if you got the answer within the range. I just want to, now 9 out of 10 hands should go up now, right? Because you picked the 90% range. Let's just see what happens. Okay, all right. So the first question, Giuseppe Garibaldi was, 86 years old when he passed away. How many got that, the range right? No, I'm not seeing 9 out of 10. We're seeing maybe 1 out of 10. Well, you'll do better on the next ones, I'm sure. All right. The Nile is 6,736 kilometers long. How many got that right? Yeah, but I'm still not seeing even 50%, you know? I just note that. Okay. Number of member countries in OPEC, 13. No, well, one of the, no, he's taking his hand down now. Okay. No, you did better on that one. Good. Now let's see about the Old Testament. There are 39 books in the Old Testament. 39. How many got that right? You weren't paying attention in Sunday school. All right. Weight of a Boeing 747 is 177 metric tons. How many got that right? Nah. Okay. Final question. A gestation period of an Asian elephant is 645 days or 22 months. Elephants are big. How many got that right? All right, so what we've shown is that you have failed the test just like everybody fails the test. Everywhere in the world, I failed the test. Why did we fail the test? If we had more time, I would explore it with you. It is because we human beings are judgmentally overconfident. When we try to assess things that are uncertain, we don't like to admit how uncertain we are. So we push the range too narrow instead of as broad as it needs to be. And I think I'm indebted to Marjorie for this. It turns out that when people place a bet, place money on their opinion, they're even more sure they are right. When people place a bet on a horse, if they place the bet, they are more sure they picked the right horse than people who didn't. Now, you think about this. What do lawyers have to predict that they don't really know? The likelihood of winning. What does this tell you they will do? They will put it close. They'll admit, one never knows for sure, but I would say between 60 and 75%. In fact, it's 40 to 90%. And do they spend money on their prediction? Yes, clients and lawyers both do, which makes them even more sure that they're right. So we end up with perfect. It's easy when they're bluffing, they're claiming that they're going to win when you know and they know they're not going to win. But here we're dealing with people who really do believe they're going to win. That's harder for me as a mediator than people who are just pretending. All right, so what do we do about this? Well, there are various things we can do about this. And now I turn the screen over back to Marjorie.
I think for the videos, am I correct?
No, I thought, oh, yes, if you want. Would you like me to show chapter 10, which is, oops, I've got to set up the video.
on our little outline, that's what I have happening next.
Say what?
I said on our little outline, I think that's what we have happening next.
You are absolutely correct. Okay.
But
we're now jumping ahead in the mediation, and we're going to have you giving an assessment, an evaluation to the, oops.
But let me just say this with respect to the
evaluation. Go ahead while I'm
evaluation.
setting it up.
Okay, what, if I remember, I watched these again last night. I, at this point, am taking the lawyers and asking them for, I'm structuring it, but I'm asking them for their assessments, at least on the first one and maybe on the second one, in a very structured way. And I'll talk later on about even if a mediator is going to give his or her own opinion, you want to be able to piggyback a little. But this is analyzing issues with counsel and then helping see where that might lead.
What I thought I would do is look at the litigation piece with you, because I've been talking with them in the other room about that a lot as well. And so I'd like to talk about it with you and see. I understand that you have a theory of damages, a claim which says, you know, this was going to be a long-term relationship. It's not only governed by that piece of paper. And you made a projection of what your sales would have been, particularly not involving Chattawa, you know, under conditions that you would have anticipated. And that is the thinking that informed your $1.6 million position. I want to look at the damages that would flow from your other legal theories. Okay, so let's just look at the contract piece just for the moment. MedPro would point to the sales figures, and we wouldn't be able to show any involvement by Cho, so it would just be from Chattawa and stuff. And they would say, looks like there was cause for termination, and looks like this. So the worst case is nothing. Right? And you're just saying you don't think that's going to happen.
No.
Okay, that's fine. But when I say worst, it's worst. But then you're saying that the 90 days is your most realistic worst.
I think so.
Okay, well, let's talk about what that would be. Assume for the moment that you had a situation where the court said, well, no real cause or not sufficient cause invoked. And so under this contract, they had a 90-day termination provision. What would the damage, what would you be owed?
The way we would look at it is that if we would have a reasonable expectation of about $33,000 a month profit.
And you're getting that from the year with
from
the
our
800
prior year sales figures of $800,000.
And you get gross profits out of that of $400,000.
That's correct.
And if you divided this division,
that's $33,000 a month.
Okay.
And if we had 3 months on the contract, that would be approximately $100,000, and that's just on the contract termination claim.
And you'd cover that. One of the ways they came up with the 60 was by saying, well, they don't like using the 800 because it was the best year. Well, they understood not using the 400 because of the Chattawa problem. So they actually looked back to the 500 year, by which time, which was the year before the 8, by which time you'd been in the market for a little bit. If you use the 500 figure, that's $250 gross profit, 20 a month. So that's 20 a month. That's where they came up with 60. Okay. Do they have? I mean, right now, it's well, it's about almost about a year from the time that you got that letter. It's. Could they send you a letter tomorrow saying, now we're going to do it right, and we're terminating? Well, we're deciding to not renew as of the September 1st. If they did that, what would your?
Well, we'd have 14 months then, 14 months of damages.
Okay, so if you had 14 months of damages, if we do times 33, that's
460,000.
460, and if it was by 20, that math is much easier.
20,000. That's 280,000.
Okay, so let me ask. I know if a court just limited you to the contract, to the paper. I know you don't like that part, but if they did, if an American court did that, is the 460 your best case?
On the contract?
On the contract.
I think it is.
And there's a range that goes between 60.
I'm understanding little.
Okay. There's a range then. If it's 90 days, it could be as low as 60 to 100. If it's 14 months, 280 to 460. So there's a range between 60 and 460. If the court just said, and zero, we forgot the zero, but if a court said, no, the contract, then I just want to make sure that we're figuring the numbers the same way.
I think we are.
Okay. All right. That's helpful. And I do get that that's not what it was about from your perspective.
It's not making me very happy to see that.
Well, that's why I actually want to make sure you agree that that would be reality if a court only went to the contract.
Only looked at the contract claim and then looked at the profitability differently than we would be arguing.
All right.
So there's a lot of variables in there.
Yes, but we were thinking profits over a long time, no?
Right.
Yes.
Right. And those are the things that get you into the $1 million range.
Can you stop that for just 1 second, before you go to the next video? No, I mean, I don't need to see it again. Can we just have, I want to make one comment that I noticed, that I maybe wouldn't have noticed at the time. And that is, yes, it's analyzing the issues, but what the way that it's been done does is it's a pretty straightforward way of shifting focus. So one thing that it does, and that's true, is that when you write something down, it seems to have greater reality to us. When you kind of put it out there and you don't write it down, it has the impact of seeming less real. I know this from work with actors. I know it from a lot of reasons. So one of the things that I've done is just said, we have your other theory. I didn't say your other theory is stupid. I didn't say any of that. We said, we have it, but let's focus on this. So the very act of focusing the analysis says something and has an impact. And then the other thing that happens is that even within that analysis, I'm then not allowing the other side to ignore what should not be ignored. So she says the profits would be this much a month using the $800,000 base, doesn't really matter. And I say, yeah, if you use that, but remember that thing you were forgetting, which is they're using a different measure. And then I put that on the paper as well. So the act of doing that analysis, I'm not sure if I'm even evaluating, though I am, I'm letting them do that, is to make sure that when they evaluate it, they include things in it that they really should not ignore. So I'm giving as much reality to her per month figure as to the other per month figure by putting them both on the piece of paper. That's all I want to say. Want to do the next one?
Well, wait a second. It's important we mediators keep our promises. And one promise was that at 5:30, there would be a break. And I don't know whether there are any questions that you've seen on the chat that people would like to pose now. And then we can show the next one, which is the more articulated right after the break.
Well, Dwight, there is a question. One question in the chat. If you want, I can read this question before the video. What do you think?
Yes,
Okay.
We said we would, so let's do it.
Okay, the question is, I'm reading that. Normally, the fact that the parties may keep the control over the process is regarded as a remarkable plus of the mediation process. Don't you think that evaluation may neutralize this typical feature of this particular form of ADR?
Marjorie, do you want to answer?
I'm happy to take it. Yeah, actually. Well, first of all, I do always try to suggest to the parties that if I'm going to make a suggestion or make a move or suggest something, they can always say no. But let's leave that because they own the process. But I just want to say this. Look, if what they do is come into the mediation and think and act the way they did before, then mostly you're not going to have a resolution. So you are only doing any of this, and I'll talk more about this later, actually, if the other things that you do by way of process and dialogue and everything else are not getting you to a settlement. And if you have figured out that the reason is that they're analyzing things so differently, or failing to, one side is analyzing and one side isn't. And so, I guess that's my response. It is a different way of approaching it. Yeah.
If I were a doctor, and actually my wife had a bad knee. All right, the first thing the doctor says is, let's wait a while. Then it's physical therapy. Then it's some kind of medications. And let's wait a few months. And let's do an MRI. And after all of that didn't work, and it took from October to March, in March, she had a arthroscopic operation on her knee, which just involves taking 2 little holes and putting in little instruments and cameras, etc. The point is, we do many things. We are jumping ahead. You notice that was chapter 10 of the video, not chapter 3. And so far, she hasn't actually expressed an opinion about anything. It's not until chapter 16 that you will see me doing it. So we would almost never do it before mid-afternoon of a day-long mediation. Yeah. The next thing is, you might well say, ask the parties, would it be helpful? I often say, I could give some weather predictions, if you will, of what a court might do. Or you could make another offer. Or here are some other possibilities. And I give them a menu. And if they choose from the menu that they want the linguine, that's their choice. But I often put it in terms of 3 or 4 things I could do. And I say, and I would suggest evaluation is probably one of the later things. Here are the things you could do first. So before we do surgery, let's try physical therapy for another 6 weeks.
And I actually like your physical therapy analogy, because I think what I'm doing there, I'm not really telling them what I think. I'm suggesting that they should go through a more rigorous analysis, but it's still based on their thought process. I'm just not letting her get away with ignoring stuff totally. Yeah.
I will say, when I see people talk, it's often, they all agree there's a chessboard. One side says, but it's mostly black with a little red on the side. The other side says, well, it's really all red, except that we do see a little black shading here and there. They're looking at the same chessboard and they're seeing different things. You're requiring her to look at the contract. They don't dispute there's a contract. You're saying, well, let's look at that, but we also know there is the other part. Anyway, I see another, is there anything else?
Yes, Professor Golan, before I give the microphone to Antonio Prida, and thank you for raising your hand, but we have another question. So actually in the chat before Antonio's, and I'm actually translating this from Italian. So see if it will make sense. For an mediator, is actually an attorney, this evaluation process might be understood as a competition between colleagues. It's my understanding, like the mediator is someone acting as a mediator, but is a lawyer, and giving this evaluation might be seen as a competition.
Well, one of the great dangers Marjorie will talk about that I see is once I give an evaluation, and of course they disagree with it, and of course they're unhappy, I start thinking I have to defend my evaluation. No, wait, you've asked for my attentive opinion as a world-renowned evaluator. I've given you my opinion, and now you're not listening? Let me explain in more detail. That's real danger, because now I've taken a position against the party. I'm arguing with the party. I'm making myself useless and irrelevant. So I think that is a real danger.
And actually, yeah, I'll talk more about that. It's really why it's surgery. And the issue of the dynamic between the mediator and the lawyer is a really important one for a host of reasons. And there are some ways to manage it, but it is fraught. And so we'll talk about that, I think, after the break. Yeah.
Thank you so much.
I promise.
There's a quick question.
Go ahead.
Yeah, there are other questions. I see another question, but I don't know, maybe we would like to have a break and then to have, what do you think? It's the same, but we have Antonino Prida has raised his hand, and then we have another question in the chat. It's up to you. For us, it's the same.
It's really up to you. You are the moderator. You, Luca, Silvana.
I think I promised Antonio Prida to that we will take his question. So
okay.
Thank you. I cannot turn on my video, but congratulations for this marvelous program. I am a Mexican lawyer. In Mexico, we have a particular system by which a certified mediator, certified by the tribunal, can create a document to solve the dispute that has the same value as an arbitral award or as a court resolution. So in Mexico, it has a very strong value, the agreement obtained by the parties. But we have the practice not even to opine or not even to propose solutions. We traditionally only make questions trying for the parties to create their respective solution without our opinion, without our ideas of solution. My question in particular is, it is not better to use an independent litigator to analyze the possibilities of the parties to win in a particular case, instead of using our own role as mediator in doing such evaluation? That's my question. Thank you for the time.
Well, first place, I want to clarify that all of our evaluations are given confidentially and under a ground rule that they can never be used in court or for any purpose at all. They disappear like a bubble if the case doesn't settle. But separately, yes, I'd love to be able to roll out from a closet a judge and have the judge do it. I find that almost never, even in the largest one, you have $500 million at stake, they're not willing to pay for it.
I actually did one like that way back in the day. One, yeah, where it was a pretty highly technical question for the Massachusetts Supreme Judicial Court. And we, the parties in a very particular issue, and the parties were willing to pay for it and do it. But yeah, I just also want to say that an evaluation of what you think might happen on a particular issue or on the whole case is not the same thing as what they might or should or would settle for. I see those as quite distinct.
There are all kinds of business and personal reasons for doing something different from what might happen in court 5 years from now. Right. Yes. Oh, this is my final comment to say that Marjorie is the world's expert at doing what's called decision analysis and has published a book on it called Risk and Rigor. We can give you the reference, which takes this to quite complex methods using very simple computer, I think readily available computer software. But
yeah, actually, I just want to say that there's no profit motive here, because although my book is available on Amazon, it's also available for free download from the computer, from the publisher. So if you want that information later.
Free
But
book.
it's
A free book on
specific.
decision
I'm not the world's expert on decision trees, but I've written a lot about how lawyers can use it. And that's really what the book is. If you're interested in it, it says, okay, so you're a lawyer and you have real cases. What the heck should I do with them and how should I do it? That's what it is. But thank you, Dwight, for the plug.
So it actually could be used more by lawyers to counsel clients than by mediators to counsel lawyers and clients. But all right, let me move on. What else can you do as you try to move along? And we'll forget about the length of the Nile River and things like that. I think
Still have the Nile River up.
you have various, yeah, and I understand.
Okay.
I'm trying to think of how to get up the correct slide. Let me jump ahead and see if I can find it. You have various forms of evaluation, which one can do. You can do nonverbal, just gestures, et cetera, et cetera. You can do indirect evaluation. I'm sorry, is this showing?
Yeah.
Okay. You can do a verbal. We've seen questions. It can be tough, leading, indirect. You can show doubt or disagreement. You can start to make statements that could be very specific or very vague. And then you can go, as Marjorie has said, you could be in verbal or in writing and different kinds of writing. I've even once in a while sent a letter that counsel has asked to send a letter that he could show the insurance company to show why he had agreed to pay the money. But if I put it on a whiteboard, I know that if I leave the room, the other side is going to mark it up, which is fine. They are going to disagree and put in new numbers, which is perfectly okay. We've talked about the others. So before I evaluate, I would do other things. I would help people exchange information. I'd ask questions. I'd lead an analysis, that's Marjorie's, and then I'd indicate doubt or disagreement. And now let me see if I can set up a new share. So just take me a minute. Not that. And I think I will stick with the case you've already seen, which is the case involving the Hong Kong businessman who had made a loan to a small American company, and then the big American company swallows the small company and says, we don't see any papers for a loan. So this is Michael Lewis, and he's asking about interest, but see what he also does with the lawyer's arguments.
Welcome back.
Thanks.
And then I'd just like to talk a little bit more about how the two of you see this, and to make sure I understand what's important about this to Green before we go any further.
Well, I had one thought. I think the idea that when you're buying assets, if you buy 6 assets and don't buy 2 assets, you've thereby interfered with the contracts of the 2 assets you didn't buy. I can't believe an attorney from a good firm would say such a foolish thing. Mr. Kim, I now understand, is very familiar with American business. He knows what an asset deal is. We've shown them the contract, and it's an asset purchase. And it's a troubled asset purchase at that. You know, they might have gone broke if Mr. Kim hadn't given them money, and they would have gone broke if we hadn't bought those assets.
Okay. So anything?
No, just to reiterate what counsel had said, we are not in the business of buying failing companies as a whole. But this was one where the assets of Monitor were attractive to Green, and hence the purchase. And only afterwards did we learn of things like the issues that Mr. Kim is presenting here today.
So notice the first thing he did after listening to the lawyer say why he was right and the other side was wrong was to turn to the executive and ask something he'd already asked, which is there anything else that's important to you in this situation? In other words, he asks about interests, and he asks in a facilitative way. And he gets back, nope, they have no claim.
And if you look at that contract, that he says was they said was the vehicle for the loan to be repaired. Doesn't say loan. It just says commission.
Okay. I take that. So let me come back to my question of whether there's anything important about this to Green Consulting that I should understand at this point before we go any further.
Yes, this is a nuisance case as far as we're concerned.
Well, I understand that you think it's a nuisance.
No, but it is a case with no likelihood of success. And secondly, we have a deadlock claim on our counterclaim because they have been selling and basically stealing all the money from the sales of our software without our permission.
How do you get to stealing when there's an existing contract? You said
that was a contract with Monitor. It isn't our contract. We're not Monitor.
But the old deal's still in place, right? I mean, unless I've misread what you both have sent me, that contract is good until, I mean, you have to give them notice until.
So far, we're seeing doubt, and I'm uncertain what you're saying.
Contract with Monitor. It's not a contract.
If we were all together in Trento, I would ask Professor to distribute cans of Coca-Cola or some other beverage to everyone and ask you to deliver an evaluation using nothing but a soft drink can and your eyebrows. You can see what he's saying, even though he's not saying anything.
With Green, they're selling our software and keeping all the money.
Okay, so they would owe you for whatever, whatever your portion, Green Consulting's portion of the sale.
What happens at this point is it becomes clear that neither side knows what the other side has been selling in the 6 months since they blew up. And he fosters an information exchange that really clarifies the situation. Let me just note, and I want to move on, that once you get to beyond this, you can now give a verbal evaluation. But here's what I'd like to do. I'd like to do another test, and I need a show of hands afterwards. I'd like to show you the evaluation in that case involving the stage lifts that didn't arrive on time or did and didn't fit. And I'm going to ask you in percentage terms what you think the evaluator said was the percentage chance that the party would win. That is, after listening to it, if you were the party and someone said to you, what did he just say? What are your percentage chance of winning? I'd like to know what you think he said, just to see, all right? Because he chose to put things in words and not to put things in numbers, like Marjorie did. Okay, I've got it set up. Now let's do our little test. I'm going to show you just a little bit of evaluation he does. And again, what is it saying to you if you're the executive are your percentage chance of winning?
There was one other part about going into court that I thought it would be helpful for us to discuss. The two things that I worry about for your case, CJ, in terms of how a judge might look at it. We all know exactly what the conversation was that you all had. And part of the dilemma is that got reduced into a written document called a contract and signed. And what the contract says is July. And one of the great dangers for you is if it got to court and if a judge took a sort of a strict constructionist position, and this can happen an awful lot, where he says, look, the written words are July. Now, that has the huge implication for the dollars. And so there's a real risk here.
Let's stop right there. You heard his words. There is a real risk here. If you're the executive and you've just heard him say that, what do you think he is telling you your chances of winning on that issue are? And I'd like, well, I'm going to have to, since no one is showing their face, I'm going to have to ask, all right, Luca, please, what do you think everyone is the expert on what words mean to them. What do you think that means in terms of if you were the executive, what is the mediator telling you about your percentage chance of winning?
Oh, I couldn't find the microphone.
That's okay.
Well, maybe very low.
No, I want a percentage.
Percentage. I would say that
70%.
Well, probably 20%.
20%. Okay. I'm just going to try. Is Antonio Prida still with us? Antonio?
Yes, indeed.
What do
I
you
would
think?
say 30%.
I hear 30%. Talia, I see you have your mic on. What do you think the chances are? What does he just say?
I would go for a 30% myself. I would go for a 30%.
30?
Yeah.
Is there someone that has something very different?
Do I hear any number higher than 30? Anybody? Do I hear a number lower than 20?
Okay.
For me, it's 10%.
10, I hear 10. Good. Anything lower than 10? So I'm hearing 10 to 30. In chat, anyone higher than 30?
I would have said 40.
40.
Good.
Well, now here we go. Every time you give I'll turn it over to you, Marjorie. What have we just proved with our little experiment?
Can you pull up the PowerPoint?
I will pull up the PowerPoint.
Okay, while he's doing that, I will tell you that I remember, there it is. So I have delivered a test like this to my class and to all manner of trainings, lawyers, students, you name it. And I read off these 8 sentences twice, trying to use the same tone of voice within the 2 times, and then I vary it as I go. And these are just completely typical ranges that I would get. So I think my smallest range is 20 percentage point range, but maybe 15, but very often, sometimes I even cross the 50% line. And the reason I do this is because of a case I mediated eons ago in the Middlesex multi-door courthouse in Massachusetts, where I was meeting in caucus with the plaintiff in a construction case. And I said to the lawyer, what do you think are your chances of succeeding on this claim? And he said, I think I have a very good case. And I said, I agree with you, but what do you think are the chances? And he said, I don't know, 60%. Whereupon the client said, 60, even 65%? I thought you meant 90 when you said you had a very good case. I never would have invested this much in the case if I knew that's what you meant. So
but
percentages give you clarity.
Yeah, but sometimes I want to be vague because if I give this verbal, the client hears as much of the truth as they are ready to hear at that moment. I can always later say, when I said real risk, I meant 35% chance of winning. But if I say 35, I can never go back. So I will start general and move towards specific for that reason.
Right.
Let me, I now realize that in doing this, I skipped over what we would think of as the quote, real lecture, unquote, about evaluation, because we've shown you lots of stuff. So what is the purpose? What can it do? It can persuade a party. Can you see this?
No, you don't have screen share.
I always forget to share screen, excuse me. Yeah. It's my great weakness as a Zoom teacher. All right, what can it accomplish? It can persuade a party that there's a risk of losing, or it helps a lawyer persuade their party. It can signal, here's a limit to what you could expect to get today. Or it could signal, you really need to think about this differently. It can, even when the party and the lawyer agree, it can provide cover, protection for a decision that the party is worried his wife will criticize him for settling too little. The lawyer is worried the insurance company will be upset that he's paid too much. Both of them can be helped if they can say, well, Professor Golan said, and so on. But remember, this doesn't end the mediation. It's only a tactic. It's one tool in your mediator toolbox. Can it hurt? Yes, it can. Surgery can always hurt. It can alienate them, right? That's your big worry, that they'll decide, oh, he's ruled against us, now he's an enemy. It narrows the discussion. Now you're just talking about legal issues. You're not talking about interests. It can freeze the process, because once the mediator is given the right number, who's going to ever accept anything worse? Or people say, well, we're just going to wait until he gives his evaluation, and we want to be as far away from the middle as possible so that he will lean our way. Or it can lock me into a position that then I want to defend. We already talked about that. It's surgery, less is more. And how and when, which Marjorie will talk about, is key. If you do give an opinion, it's never my personal view. It's irrelevant. I've agreed I will never be a witness, and it's dangerous because now I really have taken sides. It's not my expert judgment. Again, it's irrelevant what my expert judgment is. All that matters is what is the judge or arbitrator's judgment. The impact of an offer, what it will happen in the other room, yes, I can do that. You saw Marjorie. Interests. Is it in your interest to stay in rooms like this? If they're ready to hear it, yes, I think you can, because you're talking about why it's in their interest. Or a prediction. Okay, if necessary. And after trying physical therapy, medication, and other things. It's a weather forecast. How likely is it, if you go to court, that it's going to rain? I don't want you to get wet, but would it be sensible to spend a little money on an umbrella? And I am only a weather forecaster. I always give it in terms of, if this case went to court 10 times, you know, I think you might, and I always start with the win. You might win 3, 4 times, but I'm concerned you might lose 6 or 7 times. Any one time, one thing or I will be wrong. One thing or another will happen. It's not going to be 35% of something, but this is my concern. So, what issue? When do I do it? To whom do I do it? How do I do it to preserve their trust, move them toward a resolution, and keep my options open, because this probably is not going to resolve the case. So with that, I think we now move to explicit evaluation. And Marjorie, do you want me to show 3 minutes of me?
Yeah, I was going to say, don't skip your video. There's one where you are, you do an explicit evaluation, and then I would jump off that.
No, this is, by the way, the only time we've ever filmed and seen anyone do an explicit evaluation. But you notice it's now chapter 16. We are a long way down the road, but we still don't have a deal. And here I am. Let's see if I can, oops, not that. Sorry, share screen. I was talking with Chris while we were out, and I was thinking it might be helpful for me to give. I should say this is still the plaintiff. We shot it with 2 different groups of people. This is a different group. Prediction, if you will, of what seems likely to happen based on my experience with the American courts if this case were tried. And we don't know in any one situation what would happen, but if it were tried hypothetically 10 times, what would be the average outcome? I don't know whether that is something that would be useful, or is that... I think it would be. Okay. Well, I think there are various theories here, and you've heard them articulated. One is that the contract was terminated for cause. And another is that essentially they gave 90 days notice to the next September 1st, in which case there would be 90 days which you'd be entitled to recovery for profits, and then the contract would terminate. Another theory is that it hasn't terminated at all. It just was ineffective, to the termination notice they gave. And Chris, if that were true, is there anything that would prevent them from sending a termination notice next week for this coming September 1st?
You know, Dwight, probably not. I mean, we'd obviously argue that that the detailed oral discussions and representations that were made should trump the language of the written contract. which is one of the reasons why Ms. Gandhi is so upset, because they had those conversations.
Yep.
It was sort of the handshake to the company meant more than what was written on that piece of paper. That being said, I think the likelihood of prevailing on that legal theory is very low.
Yeah, there seem to be three basic possibilities. One being the termination for cause, another being I'll call the 90-day termination, and the other being the 14-month termination. And I had said no more than a 10% chance that a court would find termination for cause, meaning a 90% chance they'd find they didn't have cause to terminate you. And of the 90%, about let's say a 60% chance of the 90-day termination being ruled effective, and about a 30% chance that it wasn't effective, in which case they'd have to give you full 14 months. If it's termination for cause, there is no recovery. If there is a 90-day termination and you are earning, by your calculation, over $30,000 in profits per month, that's $100,000. If it's 14 months times over $30,000 a month, that comes out to about $460,000. If there's a 60% chance that the 90-day termination would be effective, and it's worth $100,000 as a recovery, that's worth $60,000. If there's about a 30% chance that you would get the full 14 months, 30% of $460,000 is about $140,000. The average verdict would be about $200,000. And that's assuming your profits are accepted by the court. I think that's more likely than not, but it's not certain. So on average, the trial value might be in the $150,000 to $200,000 range under the American court system.
No guarantees, it's just sort of a risk assessment formula based on outcome possibilities.
I will stop before we get to her reaction.
Okay.
I turn it over to you, Marjorie.
All right, thanks. Everyone, can you hear me? Okay. Yeah, I think that whether you deliver an evaluation numerically or in prose, the problem is what Dwight said, which is you run the risk, many risks, but chiefly that they will come to see you as not neutral or somehow on the other side, which I really don't think is true. I could like them a lot, but I still think they're going to lose. So my advice, can you put up the how one?
Yes, absolutely.
My advice, actually, before you do that, let me just say this. I think this is the part where in many ways you need to be most sort of sympathetically aligned, because you are giving bad news. If I give you an evaluation and I say, I think your case is great and you're going to win and everything's hunky-dory, that's an expression, everything's great, then you're going to think I'm the most neutral, brilliant person in the world. So where giving an evaluation is challenging to maintaining perceived neutrality is where the feedback that you're giving them is going to be perceived as negative. It's not what they would like to hear. So that's the hard part. And so for that, if you put up the how slide, the answer is very gently, very empathetically, very tactfully, diplomatically, but honestly. So it's another topic, but issues around mirroring and body language and open language, all those other communication tools that we don't have time to talk about today are part of giving an evaluation when it's bad news. Will you go to the next slide, Dwight? So let me just say this. I actually wrote a book in the client counseling context called Client Science, and more about how lawyers counsel clients, but the same recommendations apply. And for that, I did some research into how doctors, speaking of Dwight's surgery, how doctors give bad news. And what literature, the medical literature tells us is that when you give bad news to someone, you should do it only after a preface. So some hint of what's going to come. Because if I tell you something that is really not what you wanted or expected to hear, there's a sort of disorientation that occurs. And so what you want to be able to do is say, I want to tell you that I have some real concerns, or I think there are some things that, you know, may be hurdles, something that gives them a sense that what's going to come is not necessarily going to be what they want. And then after that, I want to say something that is my favorite thing. You go to the next slide. I love teaching things that are counterintuitive. And you see it in Dwight's, and you saw it in one of the other, I think Eric Van Loon video. And that is, my strong advice is to talk first about the strengths of their case. So actually, Dwight, I think that's the next PowerPoint. So what you want to be able to do is articulate first, here are the arguments that I hear that you're making. And do a pretty good job of it. You're saying this, and this evidence supports you, and here is where you're coming from. So when you do that, now they remember, oh yeah, my mediator is smart, and my mediator gets it. My mediator gets my arguments and my case. And that's crucially important, because then after that, then and only then I propose that you shift to saying, unfortunately, here's the problem. And then you articulate why it is that your evaluation on certain issues are the other way, and how it is that the other side's arguments may have more weight. But it's going first to, here's what some strengths are, here's what you're saying, gives you credibility when you later articulate your not very happy evaluation and what's behind it. So that's I think a really important point, and it's one that lawyers often don't do. They just look at the negative, and I think it's stronger the other way. You want to go to the next PowerPoint? So after the preface, and after you've maybe articulated their side, I do think it's critically important, if you want your evaluation to be understood, to be straight and clear. No waffling, softening, what we would call fudging, you know, like, oh, it's pretty good, but, you know, none of that, and very empathetically. So I hear that this doesn't seem fair, and I understand that this, and I'm sorry that this is, as much empathy as you can muster. Slowly, lots of pausing in between, because they need to integrate it. Dialogue, you don't need to be defensive, let them talk about it, hear what they say. People need time to adjust, to fully integrate what it is that you're saying. And then you move on from there. I want to, let me just go to the next one. I'm going to emphasize pause and pausing, and I would say not just law students, but lawyers too, because I've seen this happen. Sometimes I'll be in a mediation and a lawyer will actually explain what the downside is, but they go really fast. And the problem is that it just takes a while. If what you're doing is explaining complicated legal concepts, it sometimes takes a while for anybody to process it. But the truth about the way human beings are made is that when information that we're receiving has a negative emotional impact, it is harder for us to grasp and to integrate. So the funny thing is that sometimes when you're giving bad news, you have this tendency to rush through it because you don't like to see pain and you want to minimize the amount of time that you're seen as giving something negative. But it's actually exactly the moment that you should slow down and pause between pieces of it and let it sit and be willing to discuss it and say, well, you know, I don't know that piece of the case. I wasn't there at the deposition. It's possible that the witness will be better, whatever it is. But the pauses that you do are not empty space. They are time for the listener to process. I think that's my take on giving bad news generally. And I think it's particularly important where you're the mediator and you have not, if it's a lawyer-client giving bad news, well, the client has gotten to know the lawyer and trust the lawyer, and they have a long-established relationship, and they know the lawyer is on their side. Whereas you've had a relatively short time of interaction with the client. And so these moments when you are explaining something that's hard for them to hear and that will have impact, whether it's in numbers or in prose, it becomes terrifically important for you to deliver that tactfully and empathetically and showing them that you get what they're saying, even though you may view the outcome differently. So that's my shtick on the surgery. It's really the shtick on the surgery that if you're in there and I am not saying you should always or hardly be in there, but if you are and you're the surgeon, that's my technique for trying to deliver the evaluation, but still be perceived as neutral.
There's more that we could say that, for one thing, once you deliver bad news, you don't expect people to be happy about it. I often think the most important thing in mediation, I think I'm sort of a grief counselor, but it's the death of a claim, the death of a case, and people have reactions not as bad as if someone had died, but they're there. But I notice we are now 4 minutes before the end, and we promised a little time for questions. I don't know if any questions have come up that we can respond to.
Well, the first question you have already answered, because one of the questions was about how to keep the rapport with lawyers when you analyze, when you legally analyze the case. So, but you have already answered, because this way of being empathetic, be very gentle in analyzing the case. I think you have already respond to this question.
The other thing is you get signals from the lawyers that they want you to.
Yeah.
They want you to be the one delivering the bad news, not them.
So. Yeah, very often it's the lawyer, you ask permission always, and half the time the lawyers are delighted to hear you evaluate. It's really hard if you disagree. Yeah, really. The lawyers usually want it.
Okay. And then we have a comment from an Italian attorney who is asking if the assistance of the attorney is mandatory at the mediation table in the US, because the same attorney says that it's difficult to meet lawyers like those in your videos in Italian mediation practice. According to his experience, most of the time attorneys at the mediation tables in Italy are very aggressive, so they act as in court, even though they are at the mediation table. So his experience says that they are not very collaborative, but competitive. But first of all, is the assistance of the attorney mandatory at the mediation table in the US?
No, I always mediate with lawyers, but especially in small cases, people can't afford lawyers. And in marital cases, that poses a whole nother range of questions, especially when the client without a lawyer asks you for advice, because you're the only lawyer in the room with them. That's a whole, much too complex for us to try to say anything useful.
I would not do an evaluation if the person was not represented.
But bouncing to the other thing, I will say that in large parts of the United States, they do not have opening sessions anymore, because the lawyers are so aggressive and so difficult that they don't think it's useful. I still do opening sessions probably more than half the time. Or if I don't, I work with each side, I get them ready to meet with each other, and then I bring about an opening session 3 hours into the mediation. But that's, again, another topic.
Yeah. So, one of the things about evaluation and aggressive lawyers, though, I will say, is that sometimes you'll do the evaluation, they wanted you to do it, they really push back on it, but then you leave the room and then they use it with the client. So it's actually very important sometimes to give them space. They don't want to, in front of the client, do it because they think it'll hurt their bargaining position, but then they go talk to the client about it more candidly than they would with you.
Okay, very good. But so if I'm right, you think that evaluation style is not the best style when you have persons at the mediation table which are alone without lawyers, without attorneys, right? Or it's a very complex question, maybe it's too long.
It's harder. It is harder.
Yeah.
But they have more need of it.
Yeah, that's true.
Where are they getting their advice if you don't give them advice?
Yeah, but in that case, maybe it's more difficult to be neutral, to be impartial. Is that an issue? No. But okay, I see that it's a very complicated. It's a very complicated topic. I am very interested in that.
Savannah, if I were the judge, I understand what you're saying. Yeah. I'm worried though. Del Pubel, you never know. You never know how he's going to react. You know, that's how I do it.
Yeah.
Not very well.
Thank you so much. This is a very interesting topic for me, but maybe we can organize another webinar on this complicated topic. Very nice. We have another question, Luca.
Yeah, but before then, I have my personal question on this. Would you, in that case, if you have a party that's not represented by a lawyer, and the mediation is not definitely going in its favor, or maybe what the other side is proposing, and they don't have an attorney can give any advice, would you recommend them potentially to go get an attorney and maybe come back on a second session?
Oh, that's easier if they have access to an attorney, yes. Although sometimes if one side thinks they're pushing them and getting an advantage, if they can, you know, but you could then say, look, I'm sorry, I'm the guardian of the process, not the outcome, just the process. And I'm worried that if we don't give them a chance, it'll just be attacked later. And, you know, that's just how I do it.
Yeah, I agree.
All right. Thank you. Thank you. So I have another question here on the chat, and I'm going to read it. So talking about strategy, sometimes the mediator may also change his own approach during the process. In this respect, to what extent passing from an initial facilitative approach to a more evaluative style during the mediation may be helpful to the mediator's job? And there's another question in the same question. So I'll let you ask the first part of the question.
Actually, I'm going to respond for Dwight because he did research on this, right?
Okay.
That terrific mediators go between styles a lot, depending on what's mediated. You did a whole study on it. And so
in one of our videos, I charted him, you know, the risk and grid with the various possibilities. In one session with the defense, he was at 12 different places on that grid. It looks like a mouse, you know, going around looking for cheese because he's just going to different places. He never gets very evaluative, but he does get somewhat evaluative, but he then goes back to being facilitative. It is not one thing or another. There's physical therapy after surgery and medicine after surgery.
Okay, and the second part of the question is, whenever a mediator is ready even to change his style to become more evaluative, isn't there the risk for him to be regarded as less credible?
Yes, there's the risk. Marjorie talked about how to manage the risk. Surgery is risky.
Yeah.
I'm having surgery in June and they gave me all these things, bad things that could happen. They could happen, but they're not very likely. And good surgeons can avoid them. But they can't make them zero.
Right. It is, when you say credibility, you mean credibility as a neutral?
I think that's what he meant. Yeah. Mm-hmm.
That's the risk. That's really the risk. Mm-hmm. And I do separate and articulate the separation between what I might predict, and I don't know the case as well as you do, but my perspective is a neutral one. But that does not mean, that doesn't dictate where the case settles or what might be fair. It's just one thing to think about. So I try to separate that. I would say, by the way, that if I suspect that a case is going to want an evaluation at the end, because it's only at the end, then I actually try to be almost inscrutable, that they can't tell what I'm thinking until that point. So I'm super facilitative and super not trying to leak, so that I didn't lose my credibility all along the way.
If we had more time, I would show you our Hong Kong mediator. They believe in evaluation. She's totally evaluative, except I can see her expression and I know what she's saying. And I think the clients do too, but I think that's an accepted way in the Hong Kong culture to communicate an opinion. So she's being very effective, but technically she's not evaluating under some theory that it has to be explicit. I also say that I've had attorneys be very angry with me for my opinion, then they hire me again because they wanted someone to argue with. You know, okay. Anyway, I see we're past time. I've got more time, but I don't mean to.
I have another question. I have another question from the chat, and this is: have you ever needed to talk only with the lawyers because maybe you needed space, client-free space, in order to talk only with lawyers to discuss legal positions without the client?
You would see, for example, in the Hong Kong video, they repeatedly call for lawyer-only meetings when they talk about how to handle the clients and what's going on and what should we do next. If I've got lawyers who are, if I think the problem is with the clients and not with the lawyers, which it often is, then the lawyers are an ally and I can bring them together to talk. We have a problem here. Silvana, Luca, and sometimes Luca will be very clear. I just have a client and he's just crazy. And Silvana will sympathize. And then the three of us talk about what to do about this.
Yep, I agree.
Very good. We have another question in the chat, but I don't know. I don't want to use too much time. But there is another question in the chat.
It's your call, and people. No one will be offended if people have to leave. So.
Yeah, I think it goes back to my previous question. And Attorney Julia Yudi is asking that when you suggest the parties obtaining a mediation without a lawyer to seek one, don't you risk that the other party may think that you are not being neutral?
Yes. Yeah, I think this problem of people without lawyers. I mean, one nice thing about marital mediation, at least as it used to be in the United States, it was done in 2-hour sessions over weeks. And people would have time to think between the sessions and to talk to their lawyer. But the lawyers wouldn't be there during the mediation itself. That's changing. It's getting more like legal mediation, but still, I think this is a whole nother topic, and it is an ethical problem that we haven't solved.
In the United States, actually, there are issues around whether if you evaluate in a mediation, is it the practice of law? And then what is do you risk that the unrepresented party will think that your role is more of an advisor? So that's why it's a whole separate topic. It's a whole separate
I'll
topic.
tell you that you may know Peter Robinson up at Pepperdine, Luca, but he says that you California people, you say you're giving legal information, not legal advice, just legal information. And if you can tell the difference between one and the other, you are more perceptive than I am.
Yes. Well, thank you. Not sure there are other questions. I don't know, Professor Della Bontà.
I don't see any other question. I know only one. Well, the speakers refer to legal evaluation, but is it also acceptable? I'm sorry. Is it also acceptable other kind of evaluation? Not legal evaluation, but other kind of evaluation.
Marjorie?
Well, I'm not sure what for example, if I have a case in which there's a business, I just did one of these, there's a business and there's a question about what would happen to the business if they settle, I'm not really in a position to evaluate. I am in a position to ask some questions that might spark some evaluation. And I think what we said at the beginning of the program is that very frequently mediators are evaluating what they think the impact of a certain offer will have. Sometimes whether a term that's proposed is going to be implementable, whether, there are things like that that we might provide feedback on. My sense of those types of things is that they're sort of less dangerous. They're less like surgery. Yeah. I think we do it. I think it's okay that we do it. I think we're humble about it. We should be humble about all of it. But it's less dangerous.
If I say, I'm concerned about the impact of this on your business, I'm concerned about what this will do to your family, I am not judging you. And I'm not saying you're wrong or you violated any rules. I'm talking about what's best for you. And that I think is much less dangerous.
Yeah.
And you understand instinctively why. So that's why when they talk about evaluation, usually what they mean is legal evaluation, not all those other kinds.